Welcome to U.S. Immigration TV. In this video, I will discuss how it is possible to bring certain family members to the U.S. without having to file a new petition. It's through a process or procedure called following to join. So, make sure to watch this video until the end to learn how to take advantage of this procedure. And of course, make sure to like, share, and subscribe to this channel. Now, the reason I'm posting this video is because of a consultation I recently had. In fact, I had a couple of consultations dealing with the same situation. Now, in one case, the person was being petitioned by an employer, and she came to me asking how to bring her children to the U.S. faster. In her case, she was living in the Philippines, petitioned by an employer through the process called labor certification or PERM. Now, when the priority date on that employment-based petition became current, she decided that only she would apply for a visa and go to the U.S. alone, and she would get settled in her new job, and then later she was going to deal with bringing her children to the U.S. Also, her children were still in school, and she thought it best to let them stay behind for a few years to finish school. So she left her kids behind in the care of a grandparent or an aunt. Years later, she finally decided it was time to bring her children to the U.S., and what she did was she filed a new petition for them in what's called the F2A category, which is a petition by a green card or LPR parent for their single children under 21 years of age. But it was taking so long, and so she was consulting with me on ways to speed up the process. So USCIS is taking over 2 years just to process and approve an F2A petition. Now, after that, the case has to go to the NVC for further processing and then eventually be scheduled for an immigrant visa interview at the embassy. But we all know about the backlogs at the embassies and how hard it is to get an interview, especially because of the situation caused by the COVID-19 pandemic. There's embassy backlogs, there was an immigration ban, and of course the embassy has reduced staffing. So I advised her that many petitions already include children and spouses. In fact, I've posted several videos about which family members are included in petitions, such as employment-based petitions and most family-based petitions, except for petitions by U.S. citizens of their immediate relatives. In other words, there was no need for this mother to file a new or separate petition on behalf of her children, as her employer's petition would have enabled them to be processed and scheduled for an interview under the employer's petition. Now, this is called following to join, and it applies to both employment and family-based petitions. Now, technically, there's no time limit when a child or a spouse must follow to join the principal beneficiary, as long as the principal beneficiary remains an immigrant and they maintain the relationship of spouse or child. For example, if a married couple terminates their marriage before the other spouse immigrates, they would not be able to follow to join because they are no longer considered a spouse of the principal. On the other hand, if the principal beneficiary naturalizes, then the family members can no longer follow to join under the petition. Once they naturalize, the petition and following to join is destroyed. In that case, yes, a new petition would have to be filed. Also, if a child ages out, they may also not be eligible to follow to join unless they qualify under the Child Status Protection Act. Now here, it can get very tricky and confusing because in order to preserve a child's eligibility under the Child Status Protection Act, the child would still be required to what's called seek to acquire a visa within 1 year of when the priority date became current, even if they plan to follow to join years later. Now, it really sounds strange and contradictory that on the one hand, the child is not planning to pursue their visa for several years, and yet they are still required to notify the NVC within 1 year of visa availability to preserve their CESPA eligibility. But the point is, no new petition is required to be filed in order to bring certain family members to the U.S. if they qualify as following to join beneficiaries. Now, even if the principal beneficiary adjusts status in the U.S. and their family members are back home in the Philippines or some other foreign country, they are still eligible to immigrate under the original petition. And the principal beneficiary does not have to file a new or separate petition for them. Now, if you or someone you know could possibly benefit from this process, I would of course strongly recommend that you consult with an attorney right away. Now, the reason I'm saying right away is there are certain time limits, and you want to make sure that those time limits are not passed by. You know, for example, the sought to acquire requirement so you can protect a child's CESPA eligibility. But the point is, go see an attorney who can evaluate your situation, see if you're eligible, and help protect your child's CESPA eligibility and processes followed to join. And in many times, it is much faster to bring a person here to the U.S. through following to join versus a new petition, especially when USCIS is now taking years to process and approve petitions. So I hope you have found this video informative. I hope you found it helpful, whether it's for you or someone you know. And if so, of course, make sure to share this video as well as like and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.